Service Board meeting together for the January 14th, 2015 meeting at 9:30 a.m. If you'd call the roll, please.
Yes. Bart Howard.
Present.
Elizabeth Trinkler. Here. Elizabeth Dixon. Here. Chip Hellman. Absent.
Notice of meeting, if you'll read that for us, please.
Of course. This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website, included as part of this year's meeting calendar since August 4th, 2014. Additionally, the agenda for this month's meeting has been posted on the Tennessee Collection Service Board's website since January 8th. This meeting was also noticed on tn.gov's public meeting calendar.
Time to time, we approve the Robert's Rules of Order, that we use those Robert's Rules of Order in our meeting, and it's time for us to do that. Motion that we approve the use of Robert's Rules of Order.
So moved.
Second.
And seconded. All in favor?
Aye.
The agenda has everybody reviewed the agenda? Is there any changes or additions that anyone would like to make? Motion's been made.
Seconded.
And seconded. All in favor?
Aye.
Minutes. I received my minutes in the mail last week, or in the email. Those, I wasn't at the meeting, but I reviewed them. So I guess.
But they don't, I'm not quorum.
You're present, so,
Okay.
I mean, we can,
If you reviewed the minutes.
Well, I wasn't here for the meeting.
You watched it on TV.
I watched it on TV. Is there a motion that we approve the minutes of the September 10th meeting?
Being present at the meeting, I move that we adopt the minutes.
Made, seconded. Is there a second?
I will second it.
All in favor? Aye.
Aye.
Okay. Ms. Keeling Baird. We have you. Brian, did you want to be introduced, Keeling? Okay.
Yes, sir. Thank you.
this is Tony.
I would like to introduce Ms. Baird. I'll introduce myself first because I believe we probably have not met before. My name is Tony Glandorf. I am the Chief Counsel. Keeling. I also previously supervised Chris Whitaker before he left us. It's a big step in his career, and he did an excellent job here, and I hear that he's doing very well over there. I would like to introduce Keeling. She has been with the department for over 4 years. She has been the attorney for multiple programs, including the Tennessee Real Estate Home Inspector Licensing Board, the Scrap Metal Dealers Registration, and she's also served as the attorney for the Motor Vehicle Commission. She also currently is serving as the board attorney while one of our coworkers is out with a new child. So Keeling is a very busy person, and she has so many boards because she does such a good job and that she is so competent that I have complete confidence in her work, and she's going to smile because she takes compliments well, but she does a very good job. And I wanted just to introduce myself to you all and let you know that I am here to help in anything that you need. If there's any issues that those through Keeling, and if it rises to me needing to assist you, I'm available for that. And I want to let you all know that we're best that we can to provide you with the most competent legal advice for your board. All have any questions of me?
Not other than thanking you for letting us have Chris for the, I guess, 4 or 5 years that he was with our board. I know for myself, I learned a lot. He was very diligent, a super job, and I was just complimenting Kimberly on the whole staff and I've been on the board since 2003, and when we used to have complaints, and we'd have 200-300 complaints behind, and now I know 5 complaints. It's just phenomenal what this board has done, and I'm proud of what we have here now.
Well, thank you very much. I'm Appreciate that. We appreciate that very much. I will say that generally with the changeover of an attorney, it's usually a learning curve for everybody involved in this process. So if there are things that you think that we could discuss or look at, just please let us know, because everybody have differences, opinions. That creates just a little bit of confusion, but we will definitely work through that. Thank you.
I offered Keeling, and I'm sure the rest of the board would offer their assistance should she have any specific information about what's a collection agency do. Then we're
That's a good place to start.
I understand. Yes.
we're available to her to answer questions in any time, of course.
Thank you so much.
I called you Bill and Brian. Now I'm going to call you Tony from now on. So thank you, Tony. Okay. Keeling, you have an Attorney General's opinion that you want to read to us?
Legal report is first.
Oh, is that the legal report?
Yes, on tab 2.
Us to read. We've had lawyers that want to read the reports, to read them into the record, and we've had lawyers that don't want to read them into the record. How do you want to do that?
Normally, for all of my other boards, they usually want me to read them into the record. If you guys prefer me to do it a different way, I'm okay with that too.
I appreciate the reading into the records, because sometimes I might be a little bit behind, or I may miss a word or a conjunction somewhere and miss it. So if you don't mind, I'd appreciate you reading them in.
Good. Are you ready?
Yes, ma'am.
And she's gonna read every one of these?
She's going to read the complaints, yes.
I'll try to read quickly.
Yeah, it won't
Okay.
take any longer than us reading them.
Okay.
You'll see.
Item number 1, 2014-014-981. Respondent harassed complainant by phone regarding an alleged debt. Complainant alleged that complainant took out a deferred presentment loan in September of 2013. The loan was in the amount of $1,500 at 149% interest rate. When it was deposited into complainant's account, it turned out it was only $1,000, and the other $500 was taken for a fee that complainant was unaware she would be paying until after the fact. Complainant alleged that complainant has a list of 12 numbers from numerous states, all of which are used by respondent to call complainant day and night. Complainant alleges that the loan taken out from respondent should be void and unenforceable, as respondent is not licensed to do business in the state of Tennessee in regards to conducting business as a deferred presentment service through the use of the internet, fax, telephone, or other means. Complainant alleges they have no physical building. Allegations, respondent applied to the board for 2 additional licenses for other office locations, but the board denied those applications based on respondent's licensing and disciplinary issues and other. On January 5th, 2015, respondent voluntarily surrendered its license with the Collection Services Board operations in the state of Tennessee. The recommendation is to close and flag this file. Exactly means, but it just means we would close it at this time, but we would flag it in case this particular respondent decided to try to reapply in this state.
How does the complainant feel? Is the complainant been satisfied? Just by them closing their businesses, he's okay?
I didn't receive any further correspondence from I'm assuming that this would be okay.
Okay, but, and this was a collection agency that was doing that? It sounded to me like a loan company.
Well, it was, I think they were doing a little bit of everything.
As a loan company, they have a perfect right to collect their own debts without involving the collection services. So, but they did have a collection agency license, and I'm not sure why.
Correct.
Okay. I'm okay. Is it, y'all have any questions? Okay.
Yeah, it's very strange, though. I mean, it does.
Yeah, that's all. That's all we need.
There's no other action we can take.
Nothing we can do, but okay.
Next.
We'll need a vote for each.
I'd entertain a motion to accept the legal reports recommendation to close and flag.
Can I?
Yes, sir.
I have to make a motion, then I can question.
You could make a motion.
So moved. Question.
Yes.
Can we not make a motion to cumulatively vote at the end?
Is that what you're used to doing?
Yes.
Just as a whole? I'm fine with that.
Yeah, yeah.
Okay.
This-
I would
that's a
amend
new
my-
process for
Changes, we
me,
just
but
make-
that's fine.
I would amend my motion that we move to cumulatively vote at the end after we've reviewed everyone, and if there's any particular item in that motion, we'll point it out that that item needs to be redone.
That's probably fine. It's again, other boards that do
I'll
each one
second.
vote on each one, so
Well,
it's
a
fine.
motion in a second, so.
Yes.
Okay.
Motion and seconded. All in favor of the motion, say aye. Aye. Okay, motion carries.
Item 2, 2014-015-201, this complaint was filed by a former employee of respondent and alleges respondent is failing to maintain sufficient funds in its trust account to disperse monies due to all clients. The complaint alleges failure to report and pay clients the net proceeds of all collections made within 30 days, pay past clients payments received, and voiding or deleting client remittance. The complaint alleges deleting accounts from the credit reports of individuals in which it has received funds and not reporting the payments to its clients. The complaint alleges charging debtors a non-sufficient check fee of $25 per check when the maximum current fee is $9. Respondent's attorney sent a response to the complaint stating that on or about April 24th, 2014, all of the staff of respondent company left and formed a different company with little or no notice to respondent and immediately began contacting clients to get its business by spreading false rumors and information related to respondent and respondent's owner. Respondent owner received several calls which indicate that complainant made similar statements to customers as they have made. Respondent claims that complainant then made an effort to try to buy respondent's clients, which was rejected by respondent. Respondent attorney stated that respondent is thriving despite the challenges it faced due to a lack of employees. Respondent stated that complainant, as a former employee of respondent, has violated his duties under the confidentiality agreement relating to customers and debtors. Respondent's belief that this complaint arises from complainant's concern related to the legalities of his On further investigation, it was stated that the CEO of Respondent Company told complainant and employee Respondent was closing its business, so they may have solicited Respondent's clients under that. Respondent CEO later said he was going to keep doing his business and would not sell accounts to or relinquish clients to the new company started by complainant and employees. On November 10th, 2014, legal counsel contacted complainant who stated he wanted to go forward with the complaint. Complainant said at that time that he would put together more information to substantiate the complaint and submit provided such information to counsel. The recommendation is as follows. Complainant failed to provide sufficient information to substantiate the complaint to legal counsel. Thus, counsel recommends this matter be closed with no further action. If counsel receives further information in the future that would substantiate the complaint will be reopened if necessary.
Question. The people that started the new business, did we verify if they have a license? They do. So they opened their own agency with a license, and the old person has a valid license. Okay.
I think in the past, when it got to a formal hearing, that
That we
we
would do
would,
that,
we would
okay.
do that, but I think at this point, I would assume, though, that the new agency would contact the clients and say, oh, by the way, you haven't been getting your money, we'll take over and we'll pay you the money. That's when we'll get the complaints, so likely we'll start getting some of those.
Oh, that's right, we're gonna wait till the end now. Okay, good.
Number 3?
Item 3, 2014021471. Respondent is attempting to collect a past employer's debt from complainant personally by harassing complainant with threats, repetitive phone calls, etc. Complainant is a former employee of Respondent Company and states he does not owe this debt or any other debt associated with his former employer, regardless of accusations by Respondent that he is responsible for the debt. Complainant stated he is the former marketing director of Respondent Company, not an executive or owner, and had no access or authority to pay media or any other bills on behalf of the complainant states that he has never received any documents from any creditor for collection of funds owed by a past employer. Respondent sent a response to the complaint stating that it is the position of Respondent that the complaint filed is unfounded. In order to assure full determination of complainant's liability in the matter, it has been referred to counsel in Tennessee. Counsel has been directed to determine the rights of both the debtor. All such rights may be fully protected within a legal context. If Tennessee law says complainant is liable, counsel will move forward with the case. If no liability is determined, counsel will close the case. Recommendation of the matter to counsel in Tennessee for a civil determination. There's nothing in the statutory scheme. Oh, 14024781. This complaint alleges Respondent is not licensed by the Tennessee Collection Service Board to do business in the state of Tennessee. Respondent sent a response stating that it is a small office of 3 collectors who have an in-house developed software system. Respondent stated it has safeguards against collecting in the state of Tennessee. When an account has an address listed in Tennessee, it flags it. A collector cannot see the phone numbers or request a letter. Respondent stated that in this case, its system could have had a glitch with co-makers. The account has a co-maker that has lived in Kentucky, and the Social Security number is not. After investigation, Respondent believes the social is false and does not exist. Respondent was experimenting with sending out letters to co-makers and believes this triggered. After looking deeper to see how many records this affected, Respondent found 24. 17 had similar issues. Respondent stated it has requested the removal of this account from the credit report and closed the account back to the client to send to a licensed collection agency. Recommendation is to close this complaint warning for unlicensed conduct.
Okay. That it?
That's it.
How nice is that? We used to have 50 or 60 we'd have to go.
It is kind of a breath of fresh air.
That's very good. I make a motion, we accept the legal report as presented.
Second?
Motion's been made and seconded that we accept the legal report as read. All in favor say aye. Aye. Thank you, ma'am. Ready for report?
The Attorney General's opinion.
Yes, ma'am. Oh, I'm sorry, I forgot the Attorney General's opinion, tab 3.
Library.
Okay.
Challenge.
I actually have a hard copy if you'd rather.
Oh, do you?
It's not just you.
Well, I mean,
have the same
I've
problem.
lost the whole thing.
We got it.
We got it.
AG opinion?
Yeah, Steve's got it.
Okay, there's a.
Thank you.
Yeah.
He's the technical guru of the group.
I'd like for us to read this privately and then and respond to it. Is that?
It is actually an opinion you requested.
Oh,
Right. I didn't know if you wanted to start out with any questions that you might have, or if you just need a chance to look over it and then let me know if you have questions. It's pretty.
I think the question that we had was, are agent, or are attorneys that are licensed in other states allowed to collect debts in Tennessee without a collection service license? Not have to have a license. Is that the way I read it?
Right, you can't just limit it to the attorneys in Tennessee. They all have the same right. So it doesn't matter if you're in Tennessee or not.
But should they be turned over? Should we turn them over to the, I don't know, the lawyers board, the professional responsibility, I guess, because
Practicing law.
Practicing law. Can an attorney from another state practice in Tennessee without some exemption? Or I know for CPAs you can practice in another state on a singular limited basis without getting the right to practice. So I don't know how it works for lawyers.
I mean, I think different circumstances call for different things. I mean, there's reciprocity and there's,
And you practice in Georgia?
temporary. Me?
Yeah. I mean, you may have a license in Georgia, but can you just start doing something in
Practice
Georgia?
anywhere
'cause
you want to, nilly-willy?
Yeah, because collecting a debt is practicing law, and there's no issue with that.
Well, I think that may be the issue is that the collecting of a debt is not necessarily acting as a function of an attorney.
But
Whereas,
it also is acting as a function of attorney on behalf of the client.
well, it may be, well, it just depends. In reality, many things I do during the day is not the practice of law, because I'm not providing legal advice, or I'm not entering a court of law, or things of that nature. Generally, I'm providing legal advice when I'm taking your facts or circumstances and applying that to the law and giving you a recommendation on that. But I think this brings up a good issue as to whether or not when an attorney is collecting a debt, if they're actually practicing law, because their license in itself is regarding certain activities, and the collection service license is regarding also certain activities. And it appears that under Tennessee law, they're exempt from having a collection service license because they are an attorney in another state. I guess your question is
If they're acting as an attorney, then they're exempt, hands down. But if they're not acting as an attorney, then they're not exempt, because they're not, just because I'm not an attorney, I don't even play one on TV, but if I were an attorney and I was acting as one, sure, you're exempt. But if you come into Tennessee as an individual and attempt to collect a debt, why wouldn't you fall under the Collection Service Board? Because you're reaching out without a license to collect a debt. Well, let's assume.
Or even if you're in Massachusetts and attempt to collect a debt here, and if you're an individual there, you've got to have a license to collect, a Tennessee license to collect that debt. But the Attorney General is saying if you're a lawyer in Massachusetts, you don't have to have a law license in Tennessee, and you don't have to have a collection agency license in Tennessee. So, the Attorney General's the final word. I'm not arguing with him. That's what he says. But I think it's a matter for the legislature to take up, that if you're going to be a law, and I do know that there are some lawyers that are out of the state that are really bad players in this business, and we don't have any control over them at all, any regulatory control over them at all, and I don't think that it's fair for them to be able to collect debts and compete with our licensed agencies that have gone through the things that they have to do to be a licensed agent, and an attorney go through law school and he's going to do collection work and not have to be licensed or under any kind of regulatory rules at all.
right. I'm trying to maybe I'll try to frame the picture that I have in my mind so that it's understanding, because I think I understand your point. I think maybe the difference is, in my mind, what I'm thinking is that the statute says not if they're acting as an attorney. The statute says if they are an attorney, meaning that they are a licensed attorney. And in my mind, I'm thinking of somebody who is an attorney, who owns a collection service company, who does not have a law firm, and his sole purpose is to collect debts for clients. But he happens to be a licensed attorney. And he says, I'm exempt.
Having a law firm, for accountants, you license your firm and you license the CPA separately. Do law firms license the firm? So if you're an attorney, then you're a licensed attorney, and you don't have to license your firm. So having an agency or a collection service as an attorney, he's acting as an attorney. But if he's out of state, do attorneys Can attorneys operate across state lines without getting reciprocity in that state? Because there's Tennessee attorneys and Georgia attorneys and Florida attorneys. You're licensed in a state.
Right?
So
No, attorneys can't practice law. You know, if you have to be licensed in that state to practice within that state within the reciprocity means and all of that. But I think maybe the difference is that from what I'm hearing from you is that anytime somebody is collecting a debt and they are an attorney, it's your understanding that they were acting as an attorney. And I'm not necessarily agreeing with that because I think that
if they're not, then they should be licensed by us. If they're acting as an individual,
I see. Well, the statute says that we cannot require them to be licensed. You bring up a good point. I would like to look at it and maybe make a better formal opinion for you all.
just because you're an attorney doesn't mean you have a godlike shroud. You have to act like an attorney to be an attorney. You can't not act like one and say I am one at the same time. I don't think that can that work? That's a good deal.
Well, it seems that they have to come either under one or the other. They're either an attorney acting as an attorney, so they need to be licensed as an attorney in the state, or they're not acting as an attorney, they're a collection agency, and they need to be licensed as a collection agency. I mean,
I think that we're trying to make a distinction between licensed attorneys and attorneys who are practicing law. That might be two different things. Perhaps this attorney didn't go that far because we didn't phrase the question that way. I think the question was, are licensed attorneys exempt? I don't think we went so far
Licensed
as to
attorneys
say
would be exempt, sure.
practicing, right.
But our statute says licensed attorneys are exempt from the collection service laws. When we ask the question of the Attorney General, we ask the question about out-of-state attorneys that are not licensed as attorneys in Tennessee. We ask that they should, I believe that they ought to have a collection license or a lawyer license, one or the other. And that's my personal opinion. When we asked the Attorney General, he didn't agree with that.
Right. I think maybe to your point is the question is that the original question is if somebody is acting as a collection service company and they are out of state, they don't have a license here, they are an attorney, whether or not we should refer those to the Attorney General's office for the unpracticed license of law.
Yeah,
that was
would be the right
your
words.
initial question.
That's the right way, yeah.
And that's maybe that's where I kind of went into this analysis on the distinction between potentially the two. The only other analogy I could give you that's similar to that is that many people people in the state of Tennessee have multiple licenses. They may have a real estate license. They may have a motor vehicle dealer license. They could have a CPA license. And when we take action against someone, we usually look at that specific license that they were using at the time. Does that make sense?
The lawyer's not using his license as a lawyer or his degree as a lawyer, then he's an individual, and we should look at him that way.
I think that I guess how about this hypothetical? What was the difference if somebody is, and this is not an argument, just to frame it, I'm just trying to have an intellectual conversation back and forth because things are just popping into my mind that if an out-of-state attorney licensed in another state is coming to Tennessee and collecting service debts, and we think that is the unlicensed practice of law in Tennessee because he's a licensed attorney, and you indicated earlier that when you're collecting debt as an attorney, you have to be providing legal services, then why wouldn't a collection agency outside of the state of Tennessee that's licensed outside of the state of Tennessee, when they come to Tennessee to try to collect, why don't we consider that they're doing the unlicensed practice of law because they're doing the same thing the attorney was doing?
They're acting as a collection agency, and they're licensed to do that. So they're in Pennsylvania, and they're a licensed collection agency in Tennessee. They can collect debts in here just fine.
Right, but I would say that if that acting as a licensed service company,
I see your point, but that's a different license. Attorneys do more than collect debt. One function an attorney does as an attorney is they can collect debts as a lawyer. And if they do that, but collecting debt also is done by others. It is done by licensed collection agencies. So you just made the bridge that all licensed collection agencies are improperly practicing law. I think that's a step too far because we've licensed the practice of collecting, just like we license the practice of law. So I see where you were going with that,
Right.
but I don't think it's the illegal practice of law if you have a license.
Right. Well, that's
It
what
is
I
if
don't
you
think,
don't.
Well, I don't think that the in my mind, I don't think that the legislature parsed out a practice of law collecting debts and said, well, collecting debts is now something that traditionally only attorneys did, but now we're actually taking that out and saying, oh, well, licensed collection service companies can also perform this function that we generally consider to be a legal function.
It's actually the inverse of what they did do, because effectively by saying we're going to license collection agencies and then saying attorneys don't have to be licensed, what you just described is the inverse of what they did. They parsed out something attorneys can do and said others can do what attorneys can do if you have a license with us. That's kind of the inverse. So yeah, they did kind of do that back door.
Sorry, I didn't mean to cut you off. The only other profession that we license that I know that attorneys are exempt from are being real estate agents. I do not have to have a license as a real estate agent in order to sell somebody else's house.
Well,
And
like-
I think the reason is because I know what all I have the same fiduciary duties, even more fiduciary duties than a licensed real estate broker.
Can't be a barber.
I cannot cut hair.
Okay, all right.
I
Well,
cannot.
and the thing
I would
too-
like to look at that question a little bit more and at the next meeting bring that back to you, because your question was originally.
You can practice accounting.
I didn't know that.
Yeah. Yeah, but I can't practice law. But I can't
Not as
practice
a
law.
CPA.
Right.
I can't help somebody with a contract as an accountant and review a contract. That's the edge of practicing law. I can't I shouldn't draft a contract for them because I've practiced law. I can read one and give them an accounting opinion of the accounting side, but I can't. Yeah, I'm a CPA. I can't.
When the
practice
statute
law.
was written, the collection service statutes were written, there weren't any, or none that I knew of at least, or probably were not available, attorneys that were in other states aggressively soliciting for business to do collection, doing collection work, and that's all they do. They operate as a collection agency. And I knew of a lawyer, it happened to be in Pennsylvania, that was doing hard solicitation for clients, soliciting clients to do their collection work with him, and that's why I brought up the question with Chris originally. If they're out of state and they're not licensed to do
Right,
lawyers,
yes.
why don't they have to be licensed to do collection work?
Right. Yes, and he had spoken to me about that, and I think that's where the Attorney General's opinion.
They're very much presenting themselves as attorneys too. I mean, they're sending very tough collection letters on attorney letterhead. I mean, they are presenting themselves as
Right.
that in the effort to collect these debts.
Right. Yeah, and that's where that's what I want to look at really, is the facts that if an attorney says you owe a debt on behalf of my client, I mean, generally, I started out by saying I do many things during the day as an attorney. That's not the practice of law. And specifically the question that I'll look at is that if you contact someone who owes a debt to a client and tell them you owe certain money, is that actually within the realm of what a licensed attorney does? Because generally speaking, we provide legal advice to our own clients, or we enter court.
Or you represent clients. Subrogation is a common thing for law firms. You know, they represent a client to the consumer. That's pretty. There's a lot of law firms that are good-sized firms that have a unit or a group that will represent their client, the principal, and go out and collect the debt or reach out to another person and have them do something for their client. They're representing the client. But I had another point I wanted to make to you. Law firms, if it was one guy in his office who had the law license that did the letters, we're talking about companies with several hundred people or 50 or 75 people who get on the phone and say, hi, I'm with attorney such and such's office and I want to collect the debt. That's really spreading it. That's a different thing. So there's some large law firms, as Bart was saying, that do nothing but collect debts.
Oh, yes, I understand that. Well, I think that's a great set of facts that we'll look at. I'll look at that, and we will get something back to you, some kind of an opinion as to. Like I said, when you brought it up, it's a great idea. We'd probably have to go back and do more research, because I would imagine that there has been some kind of, maybe not here in Attorney General's opinion, probably not, they would have referenced it, but I imagine there may have been a court case that come out about that, or that question has come up. But it's a good question.
Tennessee, I think you can see the confusion and the potential harm to threatening things, and just the thing that even getting a letter from an attorney folks in a consumer saying things about what they're maybe going to do or what might happen when this person, what sort of misrepresentation is that to me as a consumer to get?
That's what,
That
and that's
doesn't
what,
fair like a, that doesn't seem like a fair representation.
right,
to
and
the
that's what
consumers.
we're gonna look at. I mean, I've never seen this hypothetical before, but, many a times you will have attorneys from other states who somebody will retain to assist them with an issue that they may have in Tennessee. And the attorney,
That attorney have to be licensed in Tennessee to reach
for
across
many,
the lines?
for those that I've seen, no, generally because they haven't entered the court system. But I'll look into it. I mean, I will look into
They
it.
would actually have to litigate a case in Tennessee.
If they did
And
that, they would have
typically,
to.
attorneys refer to other state attorneys. Typically, a law firm has relationships with other attorneys to actually take the step of litigation.
That's exactly right.
Oh, that's cheating.
Well, they actually,
not as
here,
teamwork.
what we see more often is that attorney wants to come and argue the case. And in Tennessee, instead of getting a license, you could do something which is called enter a motion for a pro hoc vice, which allows you to temporarily come into the state without having to actually get a license. But they do actually have to pay all of the state fees for the entire year prior to coming in.
Wow.
So we will definitely look at that. You bring up a great hypothetical, and I appreciate the intellect.
Administrative report.
Document from a prior month, and the label was not changed, so. The complaint report is new.
What tab are we going to? I'm sorry.
It's actually tab 6.
Tab 6, thank you.
Yes. It just shows that we currently have 15 open complaints, and our performance measure is at 95.
How did you get the complaints so low?
Worked
Work
on the
digital.
backlog, and we stay on top of it.
How many complaints do we get? Is the number of complaints we get a month dropping?
I haven't done any analysis. I do sort of, all of them come across my desk. I have seen a bit of slowing, that people are either not complaining or they, the companies are aware of not behaving properly, what will happen to them. So,
I think agencies on the whole are cleaning up their act. They're getting out of business. An agency nowadays can't stay in business if they don't do it right. Not just from our purview, but from the Fair Debt Collection Practices Act and the CFPB and all sorts of regulations. And there's lots of lawyers out there that are looking for agencies to sue, so agencies are just cleaning up.
tab 5 is your current budget information. And this is through November, so this does not represent the renewal cycle that we're still actually in the renewal cycle, but it does not represent the revenue from that, of course. We have 40 agencies that all expire 12/31 of the even years, and that is from where the licensure was originally put in place.
Do you have any questions about the budget? It'll be interesting to see, because this will be the first full year that we have had a budget without the collection service manager's license requirement. So I'm curious to see how we're doing.
We'll actually go to tab 4. says Delta. Application and the company liabilities, and they did assets, and the question that was asked by the board was about a note payable. It was a small business loan / startup loan, and the very first page is along with the current balance, because this is actually from
So,
and this is, again, the information, this balance sheet is from December 31st of 13.
we question it because of their negative equity.
Yes, specifically that, I believe Mr. Harb specifically questioned that note payable and wanting to know what that was. Small business loan / startup loan, and it was, the current balance is presented in the email.
Steve, I don't know how could they change that? I mean, there's still a negative equity.
If the loan had come from a principal, if one of the shareholders had made the loan, then it could have been moved to equity. But since it's really from an outside, it's owed to someone outside, they just got negative equity. Somebody needs, I think one of our rules is you've got to have positive equity. I don't know if it's a rule but that's one of the guidelines I think we use. Someone related to the company had made the loan and didn't want to have it as equity, then they had the opportunity to turn around and have equity, but apparently they.
Or maybe they need that suggestion if they would move this to equity rather than a liability, then it would look a lot cleaner on our records.
And to pay it back, they'd have to pick up income to pay it back. I mean, that's their call. They need to get their own representation as to how to have positive equity in their company. But I don't think we can advise them on that. I wouldn't want to. Kind of bound to turn their license down, aren't we?
Well, actually, the license has actually been renewed already.
Ugh.
It was renewed prior to being presented, but we can certainly get them to send us their FY 14, because again, they've shown that they won't have, I didn't ask them for the information because I know they won't have the information. By the March meeting, they might have the information.
And if you can, put in the letter that what our concerns are as a board, that we're concerned that they have negative equity. And I don't know if you could go so far as to suggest that the principal turn this loan into equity rather than they got to make that decision themselves.
Yeah, they need to get their own advice. We can't advise.
Okay.
So is that again, we'll defer in hopes that we can get there.
Likely they'll be okay by then.
If we get their statement and if they have negative equity, do we pull their license? What's the action? They're already renewed for 2 years. What do we do?
Them. That's the only.
Does the board actually open complaints?
Yeah.
Okay.
Okay, so we'll defer this until the March meeting? Okay. Motion that we defer this Delta matter until the March meeting?
With the addition, and requesting the additional
And
information.
We request information and
additional
defer receiving the information to the March meeting. Move.
second.
Motion's been made and seconded. All in favor? Aye. Okay.
And this was a question, I know Mr. Hellman was curious about this information. With the change in the statute last year and the addition of some exemptions, there was the curiosity of how many people were surrendering licenses. And I have a sheet. Prior to this, we weren't keeping exact, like a tick mark for every time someone surrendered a license, but we have started. And currently from 11/25, there's 10 licensees surrender their license. And again, we're still finishing out the renewal cycle, so I don't have numbers. There will probably be some that will just not renew their license this cycle. So I'll actually have better information in March because we will have gone past the full limit.
March late renewal?
It's 60 days.
Okay.
And we
In
meet.
February, it's late renewal. That's good to know. Thanks.
Yes. We've probably had half, 60+%, 50%, 60% of the licensees of the 239 that were expiring renew. So we large volume come through the office. So these people that are listed here, most of them were specifically stating, I think all except for one of them stating that they no longer are required to be licensed. Was their reason for surrender in our state.
Okay, so they decided that they weren't required to be licensed.
Most of the time when they surrendered their license, they send us back their license along with a letter stating their reasoning.
Review that. Did you agree with their reasoning? I don't know what.
It's really not my place. That is their private counsel advising them that they are no longer, if there was a complaint to be filed, the board's decision as to whether or not their current actions or current business practices constitute violation and that they should still be licensed.
Thank you. New business? The only new business that I'd had, I'm sorry, go ahead.
I actually have another thing, and I'll ask Mr. Glendorf to join me. This is a common question we're receiving lately. It is related to the change in ownership of a firm. And the statute states that the license is non-transferable. Sometimes they're presenting various situations to us. Statute being so vague, I'm asking if the board would possibly want to consider pursuing rules to clarify so it is very clear to our licensees what truly constitutes a change in ownership. We receive flow charts, we receive ownership percentage changes, we receive name changes, LLC to incorporated, etc. And it's very hard with the limited information we have to advise.
I've had a relicensing requirement for a 1 or 2% change in ownership. You know, that's pretty harsh.
Yeah, that was kind of, when I read the statute, that was the issue that I was thinking about, is that, you know, it says specifically here, upon change of ownership of a collection service, the new owner shall apply for and obtain a new collection service license before commencing or continuing business. So the requirement is, two things have to happen that I can see. One, there has to be a change of ownership, and two, there must be a new owner. So in a scenario where if a new owner, say it's a partnership, that's an easy scenario, a new partner comes in who owns 1% of the company, applying this statute saying that 1% owner now has to apply and obtain a new license and fill out that form with bank account numbers and everything, they may not be involved. The 1% owner could be somebody's grandchild who is 10 years old. In reality, that has nothing to do with the company. So when I read this statute, I thought, well, I'd like to get you all's opinion about this because I think we can interpret it several ways. And I wanted to see if we could interpret it to align with how you're all thinking is and actually how the industry works, because it really isn't. I'm trying to figure out what's the so what behind this. And my thinking is that maybe the so what is so that, in my mind, we want to know if that new owner is somebody who is trustworthy within the business, because there's requirements on the licensure about your business relationships and past acts and things of that nature. You all tend to agree that that's the reason for it, or
Well,
just kind of give me your thoughts on it?
On the other end of that, it may be they want to change owners so they can not pay some unsecured creditors, and in that case, in an event, they wouldn't be qualified because they're not operating in a fair manner. So I mean, I think each individual case would have to stand on its own. It's why are they, if a new partner is coming in and he owns 1%, I can say, well, on an individual basis, I'd say, yeah, that's okay. We don't have a problem with that. But if what they're doing is changing their name, not even changing their name, they're just saying, okay, we new owners are now going to our old owners, we're now going to form a new LLC, and we're going to change the ownership to the new LLC, leaving out a bunch of unsecured creditors or even clients that haven't been paid or what have you, and then hold up their hand and say, no, that's not us, that was the old company.
The thing is, though, you have more than a majority of ownership change hands. To me, the weakness in the way the statute's written is it doesn't define majority. In IRS code, there's 50%, more than 50%, 50% or greater. There's all those little edges. But if the original license ownership changes more than 50% or 50% or greater, you have to say it, or even 49% if you really want to get down and scrape anyone trying to monkey dunk. If it changes by 49%, it's a legal term, isn't it?
And I had spoken, I had spoken with Chris Whitaker when he left on this issue, because it arose from time to time. We had some discussions, and when I read the statute independently, that's the scenario that I came up with in my mind, which was, 50. If you have a change of the 51% in ownership, if there's a new controlling majority owner, that person calls the shots, and it could go. The company, and this guy could be a convicted felon. It could be a company that we regulate that's on the naughty list in a lot of other states, and we should have the ability to say no. That you all, excuse me,
Right
you all should have the
now,
ability to say no.
if there's a 1% change in ownership, and I actually had to go through that. I gave one of my sons 4 or 5% of one of the companies I had in the industry, and I had to apply for a whole new license. I mean, I thought that was a little crazy.
You get a new license. Did you get a new license number?
I had to go through the whole.
Did you have to?
They gave the same number.
Oh, it was
they
the same
repeated
number?
Yeah.
Oh, okay.
The number
Because I was
wrote,
just thinking about the economic impact of that if you had it on your letterheads and things of that nature and whatnot.
But beyond that, we have no rulemaking, which is what you raised. I'd like to see us consider that, because we need to define that whether it's 50% or 40%. The only scary thing is if you get some mobster come in at 49%. And they actually have that much, then they have they can have de facto ownership with a high percentage.
But I think
you
you all
can't avoid
could.
that.
I think that you all could. I mean, when we talk about rule making and rule changes, there's so many different ways of doing it. I've thought scenarios in my head where you could say, well, if it's a partnership, this is how it is. If it's an LLC, this is how it is. So that you could actually have it. So based on their licensing credentials, that you could have what is the criteria for what is a change of ownership in our mind. It's just an example, but we just wanted to bring it up because it's so vague in the statute. Well, I say it's vague. I don't really like to say that. The statute can be interpreted multiple ways in that there's a lot of there is a lot of requests that come in from licensees that the office has to process, and if there was a rule that provided more guidance on what to do, it could actually cut down on some of the requests as to, do I actually need to change my license? I don't know.
The situation that you described, Bart, what happened was the federal ID number to the entity was altered by more than 50%. That's a change in ownership. I don't care what the name is. So so there was a more than 50% change in ownership, and those guys would have to have relicensed under the scenario you gave. But if there's less than 50%, then that liability would move.
Well, that's not the way our statute's written.
Oh yeah,
And I I think that inasmuch as we no longer have collection service manager review, that we don't know who's opening companies and operating a company. And it may be Guido and Sylvester that are coming in and owning 1% of a new company. And I think it's important that this board know who's owning these companies. And if they change ownership by just a little bit, I think that we should have a purview over that company. I think it's important that if they want to change ownership or they want to change anything about the legal makeup of that company, they need to apply for and have a new license.
But would it be a new license, Bart? Can we just discuss this for a minute? Would it be a new license or would it be an informational application? Because if there's a change of ownership, can we not just require information on the new owner?
I mean, that would be okay, but that would be a rule that we would have to do.
Yeah, I think the statute says that new owner shall apply for and obtain a new collection service license. I mean, it's really, I mean, that's what I was,
baked in, yeah,
when
yeah.
you brought that up, it is. If it's up, we just wanted to raise the issue to you all, and it would be, I mean, it's up to you all if that's something that you all would want to pursue. It'd be a rulemaking to put a clarity on this. If you all would like for us to do that, then to look at that, not for us to do that, but to look at that, we could do it at the next meeting or some meeting down the road. And that would be, if you all would ask us, then we would look at certain
scenarios.
Because when all of your members are here, I never know how the votes would go one way or the other on that. So, but we just wanted to bring that to you all's attention.
And I just want to chime in with a little bit of administrative piece. I have 3 right here that we've received letters from companies giving us some heads up that they're going to be changing ownership. And it has become a question, something I've been fielding more and more phone calls about, and clarity for the licensees as well as the administrative staff.
A whole new license for changing ownership structure. I know of a situation where an LLC owns the stock of an agency. If the LLC disbanded and the members of the LLC receive the stock and distribution, has the ownership changed? Yeah, on the books. It's no longer the LLC, it's now the 2 principals, but the principals own the LLC. And you'd have to get a whole new license when nothing really changed. That's not an uncommon transaction given the winding and unwinding going through agencies right now.
Oh, no. I wasn't looking for an answer. I was just letting you know, just kind of adding to why we're coming with this issue at this juncture, is because we are seeing a large uptick in the number of questions we get about this.
Give us an example about what they're trying, what they want to do.
Sometimes they are 3 and 4 pages long.
Well, one was Wham.
Yes. Do you want to?
There was one where it was I think it's a Tennessee LLC that is being it's a Tennessee corporation that's being purchased by an LLC out of the state of California, wholly purchased. So now it's the same LLC, but its owner is now a separate entity. Sorry, it's the same. So, in that scenario, the advice I give is, I think that makes it no matter what. Yes, so we are doing that one. And then there's other ones where it will say we have a change in stock, and the change in stock comes from one person previously owned potentially like 90% of the company, and now they're going to own 65% of the company. Same persons own the company, but his percent ownership went from 90 to 65, something like that.
What happened to the 25%?
It went to the other 2 members who previously shared 10.
I think in a scenario like that, on a as it comes basis, we could probably send them a letter and say, yeah, that's okay.
That's not a change in ownership. That's a change in ownership percentage.
Right.
That's when reading the statute.
That's not a change in ownership.
Yes, and
that's
reading
easy to respond to.
And see, they sent that to us, but in the statute it says the new owner should. Well, there was not actually a new owner here. So, and this is kind of the scenario of things that we were trying to maybe help give guidance so that they don't provide them to the
If
the
they brought
office.
in one 5% partner in that mix, a new 5% partner, then there's a change in ownership. And they would have to reapply. There's a reallocation and a change.
So, and that was the scenario that we also talked about was what if there is a new majority, new majority owner, the scenario we went through earlier, and then what if there is a new person who would be like a 5% owner, just in that scenario, who came forward, and we don't actually have. That's where, when Kimberly and I were going through this, really what she's trying to, I think the gist of this is so that the administrative staff that gets these every day can actually give. I know it's frustrating to them, and for us to look at it and take a day and get back to them every time, I know is a little bit much. So we thought, well, if the members if the members can decide amongst themselves a good way of interpreting the statute, and we think that that's within the bounds of what the statute says, then some clarification may actually just help us out administratively to get things.
Want anybody who's an owner to fill out something attesting that they have no felony, the little boxes you check about yourself. You know, I have no felony count complaints, or, you know, that you got to at least affirm that.
Absolutely. I think that's something, we could put in that type of scenario. But yes, that's the guidance really we're looking for from the board, is what is.
I'd almost go with a 49% or greater change.
Let's try not to be
scrapes
too
everything.
specific, Steve. We start making rules, and I know that's not a rule just by speaking at it at the board meeting. There's so many things that could be, should be, that it's hard for us to say, give it a blanket on one page of paper, here's the rules, what you can do and what you can't do. If you just change the name, if you're XYZ Company and you want to change your name to ABC Company, all the same owners and everything's just the same as it was, should they apply for a new license?
I think that's in the statute, the previous statute, which says that a license is non-transferable, and that's generally, most of our programs have that, and we've said that for many years, is that when you change the legal entity, or if you sell that legal entity, that license is really
That's different than a name change.
Yes,
A
that's
name
that's
change
right,
is not a change in
non-transferable.
entity.
That's correct. I'm sorry, did you say that you were changing the
Changing the name of my
corporation?
company from XYZ to ABC.
It is
Same
a-
owner, same client, same everything, I'm just just changing my name.
Have to provide the name change to the board.
Sorry, I thought we were talking about a separate entity. I apologize.
I think that we should include the federal ID number in part of anything we consider. Because if the federal ID number changes for the entity, then that's the key. Because the name is just a name. But in going all the way back to the first case Bart mentioned, where you have two LLCs with similar appearance, and you sell from one to the other, the federal ID number changed. So if there's a change in federal ID number associated with that license, then the answer is yeah, they got to do something. But if there's no change in federal ID number, the rest of it's just puff. And that avoids having to talk about LLCs and Incs and sub-S's and all that kind of stuff. Question that you want to consider in your thought process.
I guess our intention was just to bring it to you all, so that if you feel that it should be pursued further, then we can put it on the agenda for a meeting in the future to discuss potential rulemaking.
I think if there's anything that we as a board can do to make administrative easier and more efficient, then certainly we're all for that. I just want to be careful in making new rules that we begin to give away and lose our authority over these agencies.
Right.
And
No, that wasn't the. Yeah,
and
exactly.
we don't know who they are, and we don't know what they're doing
I
now,
understand.
and there are some bad operators out there.
Right,
And
right.
We have to be very diligent about not letting those guys in our business. Just like the lawyers that I'm familiar with out of Pennsylvania, that's all they do is collection work. They don't go to court. They don't do any kind of legal work at all. They just do collection work. And they're here in Tennessee going to clients, soliciting business to do collection work as lawyers. And that's why I brought that issue up. Are we through that discussion?
Do we give them any guidance to come back to?
I think if you could come back to us and give us some suggestions and ideas about what we could do, we'd be tickled to death to take a look at that.
We will do that. If you all would like to do a motion on that, we'll get it on the minutes so that we'll have Keeling get something to you all next meeting. Just to direct us to do that.
I'll make a motion yet the next meeting that, for us to have a discussion about giving guidance in this area of ownership.
A second.
Motion's made and seconded. In favor? Aye. Okay. One other matter of new business that, and we've just had an informal discussion up here about it before the meeting started, about new applicants that are applying for new licenses in Tennessee. And this is not a renewal. These aren't people that have already had a license. But I think it would be good for us to look at those, visibly look at them to see who the owners are. Because of these three and all of us, we know the people in the industry, and we know who needs to be and who doesn't need to be. We have to have a collection manager, and we had that opportunity at that time to look at who's the manager and does he have any felonies and so forth. So would that present a real problem? Is a lot of trouble?
Presenting the applications would not necessarily be a large amount of trouble. I would remind the board you meet every other month. So someone who applies today will have to wait until March and May. Sorry, months.
I'd suggest, along with Bart, if he might, just as conversation, that we review those applications. We can always open a complaint. We just let them continue to do their work, and if we don't like it, we just open the complaint ourselves.
That's an idea.
Yeah,
Go ahead and do what you're doing now, but then just show us the applications.
Let us see them, and if we see something doesn't smell right, we'll open a complaint.
Okay, so my understanding is you want to see all new applications going forward from today. Anything we receive in the office.
I don't think change the way that you're doing, the way that you're issuing licenses is still fine, so they don't have to wait a couple of months. But then after a new license, then we'd like to see it.
Kimberly, what I'd like to ask is, in association with those new licenses, I know that the law talks about that owners need to be financially responsible. What type of information are they sending with these applications to verify? Are they sending credit reports? Are they sending things similar to what looked at the location manager? Are the owners and the managers of these agencies supplying that so that you can make a determination that these folks
There's information on the application that requests, has anyone been convicted? They're mostly just questions on the application. They don't supply anything specifically out themselves other than asking the questions, and the questions correlate with this.
That's where we've got some room. If we wanted to, just as we required in the location manager's license, if we wanted to require that the owners each provide a credit report or, whatever we might think, I think we're within our...
Do we pull a credit report on them?
I think we're within our bounds to ask that question because...
we would certainly, we can look into that to see what is allowed in statute and if there are any limitations or that sort of thing. Keeling and I can work on that for the next meeting. Definitely probably looking at reviewing your application and updating it. Going through that process.
That's what I think we should do that, and I think we should think about asking some questions about experience in the industry, as well as personal financial.
Have you ever been in an industry
history.
that was summarily closed down? Have you been bankrupt? And some of those questions. But
Some of those questions are already asked. It's a 13-page application, I
Yeah.
believe, so it's rather lengthy.
But
Oh, absolutely.
I'd love to know how much you think we could ask, you know, and what we're currently asking, and come up with a little more extensive. And I know we kind of discussed that when we knew the location manager was going away, that we felt like we already within the licensing act to still cover a lot of those. Responsibility, really.
Ask questions of the majority owner in a little further depth than the minority owners, because that's the de facto manager.
Keeling, I know our statute provides that the financial information that these agencies take to our board is confidential. Is everything else in the application a public record? If somebody wanted to know the owners of a particular company, then that would be a public record.
As far as I know, it would be.
Okay.
Right, they have you
Yes.
can do a business search and
Now-
it's usually.
A business search by the name and go online, get their ID number, all kinds of stuff. It's already available on the website. Yeah.
I'm not sure what it would be. I just knew that the financial information was confidential. I knew what else was confidential.
If someone were to want to request that, we do require a public records request. There's a form.
Anything else?
Don't hand that out. I do have one small item that I was made aware of this morning that they wanted us to go ahead and discuss. There is proposed legislation. I don't believe that it has been filed. That I do not fully know the history. I believe that's something that Chris discussed with the board, or the board budget requirement from the application, because it is open-ended. Or feel free to provide me with any details that are
Budget
from prior.
requirement's a joke.
It's a joke, but
Yeah, it's not a funny joke either.
But a bigger issue is if we open the statute up, then the next thing you know, they're going to somebody's going to make an amendment to do this. We got the Rialto opportunity here that we had, and some statutes were changed because of that. If that's the only thing that they're wanting to change, I don't have a bit of problem without having that. I wonder where it comes from. I wonder who's.
This is something the department would. This is based on comments and questions that have been with attorneys over the past. Our proposed package. So it may become, I'm giving you the like I said, it has not, to my knowledge, been filed, but one of the things we've been trying to do over the last 2 years is really keep the board informed about the legislation. So, of course, in March, I'll have an update if it's been filed and any movement. If it does file in between, if someone is interested, I can make sure that you're aware of the bill number that is attached to it.
As long as it's just removing the budget requirement, the budget provides us no real information. The financials do.
And that is my understanding. It is limited, on our part, it is limited to that. That is all that we've requested. Not to say that someone could not amend it. But
Add something else
that
to
is
it.
that is a limitation of what I've been told has been proposed. So, but I will absolutely update when it is filed.
I don't have any problem removing that budget rule either, because it was just Anything else, anybody? Okay. We stand adjourned.
Thank you. Happy New Year.
Happy New Year. It sure is. What are you gonna do with your, what are you gonna do now, for goodness sake? What are you gonna do?
What am I
You
gonna,
gonna
what
go
am
to
I not
Spain?
gonna